Tracy Equazi, can you help us with Robinson versus Omer when we get to it? I promise you'll be on for next week. And there'll be high expectations since you'll have a week to. Okay, Daniel Bullington. What? Yes, you did. John Maddox. Where's John Maddox? Okay, so he's really not here. There was a student one year who, what?
You're going to say,
huh?
You're probably going to say that somebody didn't stand up and call him.
Well, that happened. That's happened more than once.
Oh.
But there was a student who was on the attendance bubble, and if he had missed one more class, the school would have dropped him from the roll. And he knew that. And he was out of town on business on class night. So he knew he wasn't going to be here. So he had his sister come in his stead, who's not a student. And when the roll got to where the student normally sat, I realized that a stranger signed the roll, somebody I'd never seen before. And so we did a little bit of investigating, and sure enough, he knew that he was on his last absence. So he talked his sister into coming to class for him and initialing his name to the roll. And as you might imagine, his legal career came to a screeching halt before it ever really got started. But to your point, there have been not many, but there have been a number of times over the years where I've called on students and they're here and they don't answer. But you may or may not have noticed that when that happens, I'll call on somebody, they're not here, they're first up the next week. And then if they're not here that week or they don't answer, I check to see whether they signed the roll. So that has happened a few times as well. Maggie Lynch. This is torts, right? I mean, I didn't just wander into some strange class. Miss Lynch is not here. Well, we know who will be up next week. Got a list going here. Allie Forsman. Robinson versus Omer. All right.
Oh, there's John.
This is one of the most incorrigible groups I've ever had in 35 years. I mean, you all just take the cake. Mimi Herring. Miss Herring. Heck, I'm done. I'll talk about the other ones. But those of you who are on next week, be ready. Our expectations are high. All right, so we're going to spend a little bit of time finishing up strict liability. I think, as I mentioned at the outset of last week, strict liability is a theory that you see typically in three categories of cases: those involving animals, and we covered that last week; those involving abnormally dangerous activities, which is what we're about to spend some time on; and then the third big category are cases that involve defective or unreasonably dangerous products. And we save that for torts too, because we spend about 4 to 5 weeks on just that category of strict liability. So let's think for a few minutes about the second category of strict liability cases, those that involve what the courts call abnormally dangerous activities. Not just dangerous activities, but abnormally dangerous activities, or sometimes you'll see it discussed in the cases as ultra hazardous activities. Not just things that are hazardous, but ultra hazardous. So the legal significance of those labels are basically this: if the defendant has engaged in an ultra hazardous or abnormally dangerous activity, they are strictly liable if something goes wrong. They are absolutely liable if there is personal injury or property damage that stems from that activity. And that's true regardless of the degree of care used. So as we talked a little bit last week, it doesn't make any difference in these cases whether the defendant was negligent. It makes no difference whether the defendant puts on tons of proof that they complied with what a reasonable person would do under those circumstances. That kind of evidence in a strict liability case just is irrelevant. It means everything in a negligence case, but not in a strict liability case. So regardless of the degree of care used, or stated another way, regardless of how careful the defendant may have been, they are absolutely liable. They are strictly liable when they engage in an ultra hazardous or abnormally dangerous activity. That's the rule. The litigation in these cases don't really focus quite so much on that rule as they do in trying to figure out whether a given activity is in fact abnormally dangerous or ultra hazardous. And you saw the court go through that exercise in the Sterling case, where the court was confronted with this large chemical waste dump, illegal chemical waste dump at that. And the operator of this toxic waste land argued that, at least under Tennessee law, there's only one type of activity that's been deemed abnormally dangerous or ultra hazardous, and that's what? Anybody? What is it? The use of dynamite, blasting. And in fact, that is the classic example of an abnormally dangerous or ultra hazardous activity. So the plaintiffs here argue that putting 300 some odd thousand 55-gallon drums of chemical waste in this particular location and putting hundreds and hundreds of cardboard boxes with toxic materials in them in this location, and in some instances just throwing this stuff on the ground, and a bulldozer would then run over it, and the contents would just spill onto the ground, and then it would rain, right? And it would leach down into the soil and eventually into the water table, and the plaintiffs argue, this is water that we drink. We bathe in this. We cook with this toxic stew created by the defendant. And the defendant, again, argues, well, not quite so fast. There's only one abnormally dangerous activity, and that's blasting. The court disagreed, right? The court found that yes, blasting does qualify, but so does operating an illegal chemical waste dump. And the defendant, therefore, was liable for more than $1 million in compensatory damages and punitive damages, and it was a big case. By the way, did anybody read all 235 pages of that opinion? Nobody? Usually there's one or two that fib and say they did. Well, you just don't love the law enough. Disappointed you didn't read all 235 pages. Let me ask you this question about that case. How does the court figure out whether a given activity qualifies as abnormally dangerous or ultra hazardous? What's the analysis look like? If I were just to give you some activity, or we could just come up with some hypothetical, what framework would you use, or would a court use, to analyze whether that activity qualifies for the imposition of strict or absolute liability? Yeah, go ahead.
They would look at the existence of a high degree of risk of harm to others. They would look at the likelihood that the resulting harm would be great. They would look at the inability to eliminate the risk by the exercise of reasonable care, the extent to which the activity is not a matter of common usage, the appropriateness of the activity to place where it's carried out, and then the extent to which the value to the community is outweighed by the danger of the action.
Yeah, that's the analytical filter right there. So no matter what set of facts you might come up with, or that a court might be confronted with, that's the analysis right there. Now, let me ask this question: do all of those factors have to be present in a given case in order for the activity at issue to be ultra hazardous? Do all of them have to be present? No. How many of them do? One? Did the court say one? What word did the court use? Some. Well, that's not very helpful. Some. I think that means more than one, but does it mean more than two? I think the court there was intentionally vague, right? I mean, it's impossible to fashion some hard and fast rule or some formula that's going to work 100% of the time, that you just dump the facts into and then it runs through some machine and then that spits out an answer. So what the court did in Sterling was to expressly enumerate the factors that we're to use. And how many was in that list? 8 or 9 of them? Something like that? A number of factors. But then the court said, all these don't have to be present. lower courts, that is, trial courts, need to consider all of them, but only some of them must be found to exist. Some. Not sure just what that means, some. I think it means more than one, but beyond that, who knows? To be sure, an illegal chemical waste dump qualifies. There have been other cases that go through a similar exercise that I didn't ask you to read, such as a Tennessee case that involved a father who had a new shiny black Trans Am. And his teenage daughter asked whether she could take out his shiny new black Trans Am on a date. And Dad, in a momentary lapse of judgment, said, "Sure, my teenage daughter, you may take out my brand new shiny black Trans Am, but do me a favor. It's low on gas. Fill it up. And here's some money. And here's the key." So daughter goes and this is before cell phones, by the way. She goes and she picks up her boyfriend, Bobby Joe. Remember him?
Yep.
Yeah. Different Bobby Joe, though. She picks up Bobby Joe. He gets in the car, the passenger side of the car. And these two teenagers were going to meet another couple at one of their homes. And then I guess they were going to leave and go somewhere from there. So she fills the car up with gas. She picks up Bobby Joe, and she drives to where they were going to meet their friends. And instead of parking on the driveway of this house, she pulls the car off the driveway and into the grass, into the yard. And it was summertime, and the grass was tall and dry. She says to Bobby Joe, "Stay there, I'm going to run in and let them know we're here." So she disappears. Bobby Joe, being a teenage boy, gets a little restless sitting there, and he looks down at the floorboard and he sees what he thinks is a firecracker. And he picks the firecracker up and he starts to examine it and starts playing around with it. And then he steps out of the car and he lights the firecracker and he throws it down about 2 feet from the rear of this brand new, shiny, black Trans Am that is now full of gas. Unbeknownst to Bobby Joe, this was not an ordinary firecracker. This was a jumping jack firecracker. And as some of you know, some of you may not know, with an ordinary firecracker, you light it, you throw it down, and it explodes. With a jumping jack firecracker, you light it, you throw it down, and it hops around for several seconds, and then it explodes. Well, Bobby Joe lit it, he threw it down near the rear of the car, and it disappears underneath the car. And it explodes, and Bobby Joe is standing there watching, waiting for something to happen, and it does. That firecracker caught the tall, dry grass on fire, and within just a matter of several seconds, that car was engulfed in flames. And Bobby Joe apparently had enough sense to know he had better run and fast. And he does that. And as he's running away from the car, this nice, brand new black Trans Am full of gas just explodes into oblivion. It just explodes. Dad is none too happy. So he sues Bobby Joe, arguing that Bobby Joe is absolutely liable. He's strictly liable. And his argument is that the use of fireworks is akin to blasting. That is, the use of fireworks is an abnormally dangerous or ultra-hazardous activity, and therefore Dad does not have to prove negligence. The court found that the use of fireworks on a, quote, small scale, close quote, small scale, does not rise to the level of an abnormally dangerous or ultra-hazardous activity, and therefore, Dad, if he's to recover, would have to prove that Bobby Joe was negligent. That is, he deviated from a standard of reasonableness. The use of that phrase, small scale, is interesting because what might we infer, reasonably so, from the use of that phrase, small scale? Might it be that the use of fireworks on a large scale would qualify as an abnormally dangerous or ultra-hazardous activity? I think that's a reasonable conclusion to draw. So, for example, come July 4th, give or take, so many towns, cities, we live in one of them, have these massive fireworks shows, right? I mean, they're just incredible in terms of their scope and size and all of that. I would venture to say that if something were to go wrong during one of these shows and there was personal injury or property damage as a result, I would guess that a court would probably find that is akin to the use of dynamite or blasting, probably does meet at least one of those requirements set out in Sterling, and therefore the defendant would be strictly or absolutely liable. So at least we know that the use of fireworks on a small scale, like in the case I described, that's not going to get it. That's going to have to be analyzed according to negligence principles. But a large scale, I would think the plaintiff would have a pretty good argument there. Yeah.
Are you comparing like the large scale massive display or the accumulation of multiple defendants working?
The number of defendants I don't think would make any difference. If it is a large fireworks production, a show, whether that's put on by one company or 50 working together, I don't think that would make any difference.
I was thinking more like a neighborhood. Say a neighborhood of 5 people got together.
Yeah, I mean, that's perfectly great. Is that a small scale or is it not? I don't know what the answer would be. But we know what the issue or issues are. I don't know how a court would decide that one, but if it's put on, by a town, city, etc., that's probably an abnormally dangerous activity. So those defendants can argue until they're blue in the face. We were as careful as technology permitted us to be. We checked and double checked and we triple checked. And it's not our fault that there was a massive explosion and people were injured. That kind of argument would avail the defendant nothing if the court found that that's an ultra hazardous activity. There are a couple other things that I think are important to understand about this category of abnormally dangerous or ultra hazardous activity cases. And the first concept here is the duty that is owed. The courts have said that in a strict liability case, specifically abnormally dangerous / ultra hazardous, the duty that is owed extends only to foreseeable plaintiffs. That is to say, a person or persons to whom a reasonable person would have foreseen a risk of harm. So, for example, strict liability would not extend to a situation where there's property damage caused by blasting that hurls rock or debris so far away that just isn't reasonably foreseeable. Yes, it's blasting, and yes, blasting is the classic example of an abnormally dangerous activity, but the scope of the duty has its limits. And one of those limits is that the plaintiff has to be a foreseeable plaintiff. Another of these limits that courts have imposed is that the harm that results must be of the character or the type of harm that one would normally expect from that kind of activity. There's a famous case, it's not a Tennessee case, that involved a farmer that raised minks, M-I-N-K-S. It was a mink farm. I didn't even know there was such a thing, but apparently there are mink farms. Well, adjacent to this mink farm was a development that was taking shape, and one of the contractors was blasting, was using dynamite. The noise from that and the concussions and all of that so upset the mother minks that they killed the baby minks. So the farmer sued the contractor, arguing, you're blasting, you're absolutely liable for my damages. The contractor argued, well, if rock or debris had been thrown onto your property or had hit the minks and killed the minks, yes, we would be strictly liable. But it's unforeseeable that blasting would cause mother minks to kill their offspring. And the court agreed with that argument. And there was no liability on a strict liability theory. Now remember, don't lose sight of the big picture here. Just because one theory doesn't work doesn't mean that you can't go with plan B or plan C. The luxury with going with strict liability is you don't have to prove negligence, right? Well, if you're rebuffed on that theory, plan B would be a deviation from a reasonable person's standard of care, and you cross your fingers you can prove that. Sometimes there is no negligence. Or there is negligence and it's just very difficult to prove. So in a lot of tort cases, the first lot from the plaintiff's perspective, I don't want to say first line of defense, that's the wrong side of the case, but you get the point, right? That's the first theory you assert. But those are two limits that are commonly found among the jurisdictions in these kinds of cases. As far as defenses are concerned, contributory negligence, to the extent that that one is still around, is not a defense in a strict liability case. So the plaintiff's lack of due care is not a defense in these cases. Assumption of risk, that is voluntarily encountering a known risk, that is a defense in a strict liability case. And then what about the big one, comparative fault? Does comparative fault principles, or do comparative fault principles apply in a strict liability case? The jurisdictions are split. Some do and some do not. And my question to you all would be, given what you know about comparative fault, and given what you now know about strict liability, why would the jurisdictions be split? Why might some say yes to that question and others say no? Why would comparative fault principles not apply in a strict liability case? You know these two bodies of law pretty well now. Why this split of authority? Yes, ma'am.
Because in strict liability cases, there doesn't have to be negligence. So how can you apply comparative fault if the strict liability is not based upon the person actually being negligent?
Okay, what were you going to say?
I was on similar grounds where if the defendant is less than 50% at fault, then it's all their fault. I don't know how to explain that better out loud. But less than 50%, then it's not negligence. In this case, if you're probably going to require negligence, you lose in both fronts.
You remember, I don't know how many weeks, or I guess it's been a few months now, when we were talking about comparative fault and immune tortfeasors and comparative fault and intentional tortfeasors. You remember we got into an apples oranges issue where intentional misconduct is just different in terms of degree and kind and culpability than negligent conduct, i.e. comparative fault. Apples and oranges, it's just hard. They just don't, or like, or maybe I described it like oil and water. If you put them both in the bowl, they'll just separate. Some jurisdictions have taken the view that this is the same problem. Comparative fault, comparative fault is a fault-based concept. Strict liability is not. So why should the plaintiff's fault be held against him when, in this case, fault is irrelevant? In other words, one is an apple, one is an orange. One is oil, one is water. They just don't, the concepts don't mesh. They're inherently inconsistent ideas. Strict liability, which does not have anything to do with fault or negligence. Why would you take a fault-based concept like comparative fault and inject that into a strict liability case? Some jurisdictions have said you ought not. It makes no sense to do that. Other jurisdictions, like Tennessee, do apply comparative fault principles even in a strict liability case. And the basic rationale there is, why should the plaintiff who is at fault in some way, big way, small way, but he is at fault for the bad thing that happened to him, why should he just get a free pass? Why, as a matter of fairness or justice, should his recovery not be reduced to reflect the fact that he was to some degree at fault? And then you take that a step further, the courts say, if the plaintiff's recovery is reduced to the extent that the plaintiff is in fault, that does no violence to strict liability principles, because the plaintiff still doesn't have to prove negligence. He still recovers, and he doesn't have to prove fault. So injecting the comparative fault defense into a strict liability case just doesn't mess up the law, strict liability law. That's the argument. And that's the position taken by the Tennessee Supreme Court. So that is my long-winded way of saying that yes, comparative fault principles do apply, not just in a negligence case, but even in a strict liability case. But at least on the surface, you see how conceptually that would give some courts pause. Yes? That is why there is the split of authority on that issue. The last thing I want to point out about strict liability before we turn to something new altogether has to do with an employer's liability. I think we've talked in here about just very basically how if an injury or death is work-related, that's not a tort case, it's a workers' compensation case, right? Where the principles are just different altogether. Well, what does this have to do with strict liability? If that case is controlled, if there's personal injury or death, and that case is controlled by the workers' compensation statutes, the employer is strictly liable for that. Meaning the plaintiff/employee does not have to prove that the employer was negligent. The quid pro quo for that, though, is yes, the employer is on the hook even though they were not negligent. The employee, the plaintiff, can only recover damages that are provided for in the workers' compensation statutes. That plaintiff is not going to get traditional tort compensatory or punitive damages. So if there is a work-related connection to the plaintiff's injury, there is no recovery for things like physical pain and suffering or mental anguish and emotional distress. No loss of consortium. Certainly no punitive damages. All of these tort concepts just would not apply. But the point here is that an employer's liability really is a form of strict liability, meaning the plaintiff employee doesn't have to prove negligence. Any questions about strict liability? Anything at all? No? Yes, ma'am.
Does the strict liability case still go before the jury?
Yes. Assuming that there are disputed issues of fact that have to be decided by a jury. If reasonable minds can't differ as to what the facts are, that is what happened, there's nothing for the jury to do, and the judge or the court can take those undisputed facts, apply the law to them, and decide the case. That's called summary judgment. That's my oversimplification of summary judgment, but it works for our purposes. Yeah, you don't have a trial in just every case. If the parties can agree on what happened, there's nothing for the jury to do. Anything else about strict liability? Did anybody go home last week and look at Fifi a little differently in light of our conversation? I don't remember whether last week we may have run out of time when we were working our way through animal categories. But did we talk about so-called wild animals? Some of you are shaking your head yes, and some of you are shaking your head no, which is interesting. There are, we did talk about like livestock, farm animals, trespassing animals. We talked about domesticated animals, pets, dogs, cats, chickens, cows, right? We made it through all that. We talked about killing another person's domesticated animal and the defenses that can pop up in a case like that. Well, let me just mention, in case we didn't get to the category of wild animals, just real quick. The owner of a so-called wild animal is strictly liable, period. So, there are people that have monkeys. There are people that have snakes, poisonous snakes. There are people that have bears. There are people that have moose. Other kinds of wild animals. No matter how elephants. In fact, there's an elephant sanctuary in Tennessee. Did you know that? There is. Not too terribly far from here. If one of those elephants, no matter how well trained, no matter how tame that bear might be, or that lion, or that tiger, or that rattlesnake, if harm is caused by one of these wild animals, the owner is strictly liable. Period. I remember driving into work one morning several years ago now, and the traffic report came on, and there was a moose on the loose in Brentwood. And it was running in and out of rush hour traffic, causing chaos, and it was just funny to listen to the reporter, just having fun with this moose on the loose in Brentwood. And I just remember thinking, if that moose causes a wreck, the owner of that moose is absolutely liable, strictly liable. It's unfortunate that people think quite that way once they have the disability of a legal education. You can't just enjoy the story. You have to think, oh, what are the legal ramifications if that moose causes an accident? Well, that's true. That is absolutely true. The owner of that moose would be strictly liable. There's an instance a couple, 3 years ago now, I guess, where somebody had a camel in upper West Tennessee that got out of its enclosure and killed 2 people. And the owner of that camel undoubtedly would be absolutely liable for that. No matter how well trained that bear is, no matter how tame that elephant might be, no matter how doesn't make any difference. Courts everywhere hold owners of wild animals strictly liable if something goes wrong. I didn't bring this list with me, and it's not important. But in Tennessee, our legislature has actually come up with a list of animals that are inherently dangerous to humans, and a list of animals that are not. I wish I'd brought that list with me, but on the list of animals that are inherently by law inherently dangerous to human beings include hippopotamus, rhinoceros, all poisonous amphibians, frogs, all poisonous snakes, alligators, crocodiles, cheetahs, chimpanzees. And in my mind's eye, I just see this legislative committee hearing in action where this bill is being drafted and some hand goes up. Oh, I have one. Let's add zebra. Yeah, that's a good one. Zebra is in the list. What about hippopotamus? Yeah, that's a good one. Baboon. Yeah, got it. And so we have this law that enumerates animals that are dangerous to humans. The list of animals that are not include chipmunks, rabbits, gerbils, and I forget what else. Squirrels didn't make the list. Not quite in the category of rhinos.
Squirrels is on the list.
What's that?
Squirrels is on the list in Class C. In Class 3, those are the ones that are allowed. I used to have a zoo, but I pulled it up to you free, so I was reading off your list. But, so I've had some of those animals that are on the
Do you have a camel?
No, we did not have a capybara, and I have coatimundii currently. And
Yeah. My memory is that on that list of animals that are not inherently dangerous were giraffes. That one surprised me.
yes, giraffes are on it.
One swift kick from a giraffe, I mean, you're in trouble. But yet the legislature in its animal wisdom has concluded that giraffes are not inherently dangerous to human beings. So I guess where I'm going with all of that, don't worry about what's on that list or not. Just if you ever have an animal case remember in the recesses of your mind, there's a statute that might help or hurt me depending on which side of the case I'm on. I have no idea whether other jurisdictions have similar statutes, but I know we do in Tennessee. All right, let's turn a pretty sharp corner now and talk about misrepresentation. The liability of which can be based on any of the three main theories we've talked about this year: intent, negligence, and strict liability. Let's deal first with intent, that is intentional misrepresentation, which also goes by the name of fraud. Or you'll sometimes even see it in some cases referred to as deceit, which is a really apt label for intentional misrepresentation, because a defendant acts fraudulently when he intentionally misrepresents a material fact to the plaintiff in order to mislead the plaintiff. And the plaintiff relies, reasonably so, on that misrepresentation. So if you want just a quick or short definition of fraud or intentional misrepresentation, that is it. A defendant acts fraudulently when he intentionally misrepresents a material fact in order to mislead the plaintiff, and the plaintiff reasonably relies on that misrepresentation. If we take that definition and break it down into its component parts and come up with the elements that make up fraud, the first is the representation of a material fact. And there are several concepts here. The first is that the fact has to be material. Well, that sounds good, but what does it mean? The cases tell us that a fact is a material fact for purposes of fraud if it would have influenced a reasonable person in their business transactions, or, not and, but or, the defendant knew that the plaintiff regarded that fact as something of importance to their particular transaction. So there are two ways then to prove that a fact is a material fact. One is an objective way, and the other is a subjective way. You don't have to do both. Either one will work. So a reasonable person would have regarded that information as important, or the defendant knew that the plaintiff regarded that information as important. So in a fraud case, it isn't just the misrepresentation of just any old fact. The universe of actionable fraud is much smaller than that. The misrepresentation must be of a material fact, not just any and everything. And there does have to be a fact involved, as opposed to what? Statements of opinion, sellers puffing, sales talk. Let's say the plaintiff goes to a car dealership to buy a car. And the salesperson says to the plaintiff, you won't find a better deal anywhere in the United States than right here at this car dealership. We will not be undersold. Or that car you're looking at right there is the best car made in America. Or that car you're interested in, I think that would be great and suit your family's needs. All of the above may well be bald-faced lies, and probably are. But that's not actionable fraud. That's sales talk, sellers puffing, statements of opinion, as opposed to that car you're looking at right there has 10,000 miles on it. You see the difference? If you cannot put your finger on a fact, there's no liability for fraud. But you say, oh, the defendant lied. Perhaps. But if they didn't lie about a material fact, there's no liability for that. That's not tortious. People lie all the time about all kinds of things. But where you cross the line and it becomes illegal is when the defendant lies, misrepresents a material fact. That's tortious. What about statements of the law? You know, people talk a lot about the law, and most of them probably don't know what they're talking about. Statements about what the law is. I hear this a lot, by the way. People call my office complaining about judges every day. Well, the judge didn't follow the law. I know the law is X, and the judge didn't follow X. So you need to reprimand that judge, or you need to take that judge off my case, or you need to remove that judge from office. Or that judge needs to go to jail. They didn't follow the law. A statement about what the law may be or not be falls into this category of statements of opinion, and thus not actionable fraud. There's a big exception, though. What's the exception? Anybody know? Lawyers. A statement about the law made by a lawyer can well be actionable fraud. Say, for example, a lawyer tells a client that the statute of limitations has not run on the client's claim, and the lawyer knows full well that it has. That's deceit. That is trickery. That's intentional misrepresentation. That's actually a case. A lawyer did that in Tennessee. I'm not sure whether I shared that example with you or not, but there was it was a personal injury case. It was a tort case where the client hired this plaintiff's lawyer, and the lawyer had not filed the claim within the statute of limitations period. And so the defendant filed a motion to dismiss, arguing that regardless of the merits of the case, the court needed to dismiss the claim. And the court did that. So the case was dismissed. The lawyer, who was a new lawyer, didn't tell the client. And the client didn't hear anything from the lawyer for some period of time and started calling the office with greater frequency, wanting an update about what's the status of my case. And the lawyer wouldn't take the call and wouldn't respond. Well, the lawyer and the client just happened to be at the same Christmas party. And so the client went up to the lawyer and said, I've been trying to reach you for forever. What's the status of my case? And this young lawyer panicked and said, everything's going fine. Don't worry about it. Everything's under control. Sorry I didn't get back with you. I've been really busy. But no worries, your case is moving right along. Knowing full well that a court had already dismissed that person's case. That is fraud. And I would add, just as a postscript to that circumstance, the Board of Professional Responsibility, which is the ethical arm, enforcement arm of the Supreme Court, took a dim view of what that lawyer did, and he ended up being his license suspended. He was disbarred for 5 years because he committed that fraud. So a statement of what the law is or isn't made by anybody other than you all is a statement of opinion, and it's that's all it is. It's not actionable fraud. But if you tell somebody the law is X, and you know or reasonably should know that that's incorrect, you can be held liable for fraud. Intentional misrepresentation. What if the tortfeasor makes a promise to do a particular thing in the future and then doesn't follow through and do that? Is that fraud? Well, it might be. It could be. So if a defendant, if a promisor says, I will do X if you will do Y, and the other party does Y, and then the promisor doesn't do X, that's a type of fraud called promissory fraud or fraud in the inducement. But here's the thing that makes promissory fraud really difficult to prove. The plaintiff has to show that the promisor never had the intention of carrying out the promise, as opposed to just changing his mind. It's not tortious to change one's mind. It's tortious to mislead. So if the promisor never intended to make good on the promise and misled the plaintiff, that is a type of fraud called promissory fraud or fraud in the inducement. But again, I emphasize there's no liability if the defendant just changed his mind. Now that might be a breach of contract problem. A agrees to do a certain thing if B does a certain thing, and there's an agreement there, the contract, there might be a breach of contract issue, but there is no liability for intentional misrepresentation just for backing out of a deal, breaching a contract. Where it becomes illegal is when the promisor never had the intent to make good on that promise. And that's a hard thing to prove. Because a defendant who gets sued for inducement fraud in the inducement is never going to admit that they intended to deceive the opposing party from the get-go. They're never going to do that. They're going to be lawyered up, and when they give their deposition and testify, they're going to say, well, I did change my mind. So there has to be a material fact. And it has to be represented. The representation can take a variety of forms. It might be written, it might be oral, it might be something by virtue of conduct, like turning back the mileage odometer on the car. Nothing written, nothing oral, but there's an action there, some affirmative act that can amount to a representation. And sometimes there's none of the above. There's just silence. There is no affirmative act on the part of the defendant. Yet, under certain circumstances, silence can itself constitute a representation. This is a type of fraud that is called fraudulent concealment. I like to think of fraudulent concealment as suppression of the truth, suppression of material facts. Can you think of an example that we've actually looked at, not once but twice? That's right. Remember the physician that put experimental hardware into the patient's back and never told him that what he was gonna, these pedicle screws and related hardware, that those were experimental, they were causing problems in other patients. He never told him any of that. Quite the contrary. When the patient woke up, Dr. Coker said to Shadrick, oh, we just did the routine. What we did to your back is just routine. And after some length of time, years actually, where the plaintiff continued to experience back problems and ultimately had all of the screws taken out of his back, he discovered that what was done to him was actually anything but routine. And the court found, you may remember, that is fraudulent concealment, suppression of the truth. And that can itself constitute a representation. Let me add, though, to this claim of fraudulent concealment. Generally, there is no duty to disclose material facts. In the typical transaction, there is no obligation to just voluntarily disclose material facts. The big exceptions, though, and this is where you see the cases come in, is where the parties have a fiduciary relationship with one another. That is, there's a confidential relationship between them. The classic example would be lawyer-client, doctor-patient, partners in a partnership. So if there is one of these fiduciary relationships, then there is an obligation. There is a legal duty to disclose material information. So that's the first exception. Second exception that sometimes will manifest itself in the cases is where a party knows of material facts and knows that the other party can't reasonably discover those facts, in which case the courts will generally impose a duty to disclose that information. The car salesman, for example, who knows that the mileage odometer on the car is incorrect, has an obligation to disclose that. And then the third exception is where new information comes to light that makes a represented fact untrue or at least misleading, even though it may have been true at the time that it was made. Let me give you an example. Let's say that sellers have their house on the market. This is actually an actual situation. I had some friends that were trying to sell their house, and they had a showing on a Saturday afternoon, and these potential buyers were serious buyers, and they were really interested in this house. And one of the questions that they asked the sellers was, has this house ever been flooded? And the sellers, my friends, answered truthfully, no. We've never had any kind of water damage. This house has never been flooded. That was Saturday afternoon. In the wee hours of Sunday morning, the sellers were awakened by the sound of a child's toy hitting a baseboard as it floated down the hallway. And what had happened was, and I don't think they ever figured out or got a clear answer as to how this could happen, but what happened was the raw sewage in that subdivision had somehow backed up and flowed into the plumbing system of the seller's house. And so in their dishwasher, in all their sinks, bathtub, shower, where water should be leaving, raw sewage came in and just coated the first floor of their house. So I get a call Sunday afternoon, panicked call, and my friends say, okay, now these buyers, they put an offer in on the house, and it's a very good offer. And their question to me was, do we have to tell them what happened? Do you think I told them, no, just conceal it, don't say anything? New information came to light that made a represented fact untrue, even though it was true at the time that it was made. That's the third category right there. So yes, you have to disclose that. And they did, and the buyers walked away. But that's preferable to being sued for fraud. There are other buyers. Fix the house up. and then take another run at it. But it's better than being sued for fraud. That's going to stay with you a long time. All of that is just the first element of fraud, the representation of a material fact. There's a lot to the first element. The second element of fraud is, I guess, apparent, should be obvious, but it is that the fact at issue has to be false, or at least misleading. Third, the defendant must have made the misrepresentation either knowing that it was false. In other words, he knew that he was telling a lie at the time that he told it, or he made the misrepresentation with reckless disregard for its truth. He knew that he was giving out wrong information, or he did so recklessly. So he didn't know whether it was true or not, but he represented the information as though it were true. For example, a lawyer who tells a client that the statute of limitations has run when the lawyer doesn't know one way or the other. So it's this scienter requirement. Have you talked about the concept of scienter in criminal law? Again, some of you are shaking your head yes, some of you have shaking your head no. Some of you probably have no idea one way or the other. But especially this late in the year, when things start to get fuzzy and start to run together and you get tired and your brain is full, I mean, this is the time of the year right here that I think the first year gets pretty difficult. Be that as it might. And by the way, when things get fuzzy, when things get difficult, what should be your automatic response? Go to sleep. Shame on you. You should put on blinders, forget about all the noise and all the other stuff swirling around, and you just consistently, thoroughly, conscientiously prepare for the next 6 weeks or so, and you'll be done. This is not the time to let off the gas pedal because you're tired. If you're tired, let me just tell you, there are 100 other people in here who are tired as well. And the temptation as we bring the year in for a landing is to just sort of go to sleep. That is a big mistake. So just continue to fight a little bit longer in criminal law and contracts and torts and whatever else you have, and you'll be done sooner than you think. Not sure where I was going with all of that, but what's that? Back to scienter. There is a tie-in of sorts. Scienter is state of mind. It's in the criminal law world, it's often expressed as a bad motive, evil intent, scienter. In a fraud case, it's expressed as the defendant knew, he was aware that he was providing the opposing party with incorrect material information, or did so recklessly, without regard to knowing whether it was true or not. And it's this, of all the elements in a fraud case, it's this scienter requirement that makes fraud not just the culpable claim that it is, but it makes it difficult to prove. Because once again, most defendants aren't going to get on the stand and admit, oh yes, I knew that that was a lie and I just told it anyway. It's just, that doesn't happen in the real world most of the time. So this is the one that makes fraud hard to prove. Number 4, the defendant must have intended that the plaintiff act in reliance upon the misrepresentation. Number 5, the plaintiff must have actually done that. They must have actually relied on the misrepresentation. Number 6, that reliance has to be reasonable. The cases say that you can't reasonably rely on information that you know is incorrect. The reliance must be justifiable. It must be reasonable under the circumstances. And so if the proof is that the plaintiff was aware or knew that the mileage on the car was incorrect, he can't go through with the deal and then turn right around and sue the seller based on the fact that the odometer was incorrect. That's not reasonable reliance. Nor is there, the cases tell us, an obligation imposed on plaintiffs to investigate the truth of what they were told. Now, their reliance has to be reasonable, but that doesn't mean necessarily that the plaintiff has to affirmatively investigate whether what they've been told about the car, for instance, is correct. The buyer of a used car doesn't have to take the car to his or her own mechanic to have it checked out just to make sure that whatever they were told about it is correct. Even if they could do that, even if they had the opportunity to do it, the law doesn't impose an obligation to do that. What if the defendant makes a misrepresentation to one person, but a third person over here ends up relying upon that to their detriment? Can that tortfeasor, the one that makes a misrepresentation, be held liable to a third party, someone that they did not communicate with? Say, for example, a company by the name, well, this doesn't work too well. What if a company by the name of Jackson Manufacturing Company wants to buy several $1 million worth of steel from a company called Bethlehem Steel on credit? So Jackson Manufacturing doesn't have the money to pay for the steel. They want to buy it on credit. And Bethlehem Steel says, we'll sell you several $1 million worth of steel on credit, but you're going to have to provide some financial information about your company so that you don't go belly up when we give you the steel and we don't get paid. So Jackson Manufacturing Company turns to its accountant or accounting firm, Ernst & Winnie, explains the situation. Ernst & Winnie puts together some financial documents, does this audit, and let's just assume, for sake of discussion, This isn't what happened in the Bethlehem Steel case. But let's just assume that Ernst and Winnie intentionally fudges the numbers to make the financial picture of its client appear to be more rosy than what it actually is. And so Ernst and Winnie then gives that information to Jackson Manufacturing. Jackson Manufacturing gives it to Bethlehem Steel. Bethlehem Steel looks at it and says, looks like you're a solvent company. Here's several $1 million worth of steel. And then what happens? Jackson Manufacturing goes belly up, right? Goes bankrupt and can't pay. So Bethlehem Steel, instead of suing Jackson Manufacturing, Bethlehem Steel is the plaintiff, decides to sue this third party over here for fraud, for intentional misrepresentation. Ernst and Winnie argues Bethlehem Steel can't recover for fraud because there is no privity of contract. Is that a concept that sounds familiar? Have you talked about that in contracts?
Yeah.
Okay, good. So what is it?
To be a party in that contract.
Say again?
To be a party in that contract.
Okay, to have a direct relationship, right? So in this example, Jackson Manufacturing and Bethlehem Steel are in privity. Jackson Manufacturing and Ernst and Winnie, they're in privity. But the actual parties to the lawsuit are not. And the question becomes whether the lack of privity will bar a recovery in a fraud case. What's the answer? Yes, sir.
Lack of privity does not bar as long as it is reasonably foreseeable to third party for violent conduct.
That's right. So these third party cases all come down to the issue of foreseeability. Is it reasonably foreseeable that a third person would end up relying upon that information to their detriment? If the answer to that question is yes, Bethlehem Steel would be able to recover against Ernst and Winnie. Conversely, if the answer is no, that's the end of that case. The last element, number 7, in a fraud case is damages. You remember, think back to the beginning of the year when we were talking about the intentional torts. And intent is a required showing in fraud, right? It's one of the elements. With the other intentional torts, assault, battery, etc., you remember perhaps that when it came time to proving damages, nominal damages were sufficient. That is to say, technically a tort was committed and the jury could award $1 in damages. Those are nominal damages. That cannot happen in a fraud case. In a fraud case, there must be a showing of actual damage. There's no such thing as a nominal recovery in a fraud case because actual damage is a required showing. It's one of the essential elements. That's the easy part of this. Where it gets into a little more of a nuance is how the courts will calculate compensatory damages. And here the jurisdictions are split. In some jurisdictions, actually a majority of jurisdictions, the compensatory award is the difference between the market value of what the plaintiff received, which may or may not be what he paid for it, but it's the difference between the market value of what he received and the value of the item had the misrepresentation been true. And when damages are calculated that way, the plaintiff gets the benefit of his or her bargain. And so the jurisdictions that have adopted this approach have dubbed this concept as the benefit of the bargain rule. Tennessee is one of these jurisdictions. So in a fraud case in our state, you would take the difference between the market value of what the plaintiff received, and again, that may or may not be what he paid for it, and the value of the item, excuse me, had the misrepresentation been true. And in that way, the plaintiff does get the benefit of his bargain. Other courts limit recovery to what the plaintiff is out of pocket. And so we have this out of pocket rule. And the way it works is you take the difference between the actual price that the plaintiff did pay, the difference between that and the market value of the item as it was received. The difference between what he actually paid for it, which may or may not be its market value, and the market value of the item as it was received. Take the difference between those two numbers, and that is the compensatory award. So as I say, the jurisdictions are split on this. The big unknown, or the variable in a fraud case is not so much compensatory damages, but it's what? Punitive damages. And this really does take us back to the beginning of the year. You remember the case that we looked at, Hodges versus SC2? That was the case where the court basically rewrote the law on punitive damages and came up with that bifurcated process. And we spent a lot of time on that. One of the things that the court did in that case was to hold that there are only 4 types of misconduct that will open the door to an award of punitive damages. One is intentional wrongdoing. One is malicious wrongdoing. One is reckless wrongdoing. And what's the 4th one? Fraud. So punitive damages can be awarded in a fraud case, which is no surprise, right? I mean, we're talking about, in terms of level of culpability, if you were to rank all of the torts that we've talked about so far in terms of their level of culpability, fraud would be at the very top. So really, it's no surprise that the courts will, or the courts can award punitive damages in addition to compensatory damages. All of that is the first of these 3 claims for misrepresentation: intentional misrepresentation. We will start here next time We'll finish misrepresentation and then go right on into the new material, which I think you'll find very interesting, defamation. So make sure I get the roll, and I'll see you next time.